Okay, everybody, you're very welcome this evening, and it's a pleasure to be chairing this joint event by the Centre for European Legal Studies and the Centre for Intellectual Property and Information Law. We cannot get any more cutting edge on the seminar that we're having this evening on EU data protection law. I mean, this month we've had the approval of the overall EU data protection package, the regulation of which David is going to be focusing on today, also the directive on law enforcement and data processing, and we've also had the approval of the passenger name records directive as well. So again, this could not be more current. And here to examine whether the European General Data Protection Regulation does constitute either a historic victory for European citizens or a false dawn for EU fundamental rights and the EU digital market is David Erdos, who is a university lecturer here at the faculty, also the lecturer in Open Society, a fellow also at Trinity Hall, and he's published a number of articles in the area of data protection, notably in leading journals such as Common Market Law Review and the European Law Review. Notably, the focus has been on the balancing, or should I say lack thereof, David, between data protection and other such...
Sometimes lack thereof.
Sometimes lack thereof of very significant rights also fall under the Charter, such as freedom of expression and those related areas. And just to give everyone just a little more context to this, we had the General Data Protection Supervisor describe the regulation as a clarion call for a new global digital gold standard, which does sound quite ambitious, but even he himself noted that the regulation was far from ideal, and I suspect that that might be the tone that we'll be adopting this evening, but we shall see. I'm not going to preempt any insights you're going to share with us, David. So just to let everybody know, the presentation is going to be recorded, so if there are any questions or comments during the presentation, that they may be available later on online. However, the Q&A session afterwards, well, that'll be subject to Chatham House rules. Okay, David, whenever you're ready.
Thank you very much, Nora, and well, the draft. Anyway, no, thank you very much, Nora, and thank you all for coming in what I know is a very busy part of the start of term. So this is really very much going to be a talk which is having a first look at the EU data protection regulation. In a way, it's a first look overview of the regulation. It's only been in print in final form, I think, for a couple of weeks. We're all kind of getting up to speed with what this final form of the GDPR is. And I suppose that is where my head is at, going through the various provisions. So I apologise in advance if it's a little bit clunky in that way. It was described by Viviane Reding, who is, I'm sure you all know, was the EU Commissioner and actually later Vice President of the Commission, who initiated the regulation, as a historic victory for EU citizens. But by Digital Europe, the trade body for digital companies in Europe, as not striking the proper balance between fundamental rights which are in tension and with the need for Europe to be competitive in the digital future as opposed to protecting individuals. And so in a way that is the context of my talk. Alongside what really this talk will be, which is a first look overview of the regulation, I'm going to build towards two key claims about it. The first claim probably is less controversial than the second. The GDPR will enhance the EU's undoubted reputation for valiant attempts to comprehensively or quasi-comprehensively safeguard the individual in a digital age. Claim number two, possibly controversial, including with our friends in Brussels, the GDPR will significantly augment and significantly entrench pathologies or problems within the EU data protection structure. It's over breadth, it's over prescription, it's very poor balance in many ways with other competing rights, and this dramatic gap with the reality of the digital that we actually see in a globalized context. So let's stick with claim 2 for a little bit, because you might already be thinking, but what about the risk-based approach? Haven't we been talking about the risk-based approach for years in terms of this regulation being drafted, and the discussions even formally started in the beginning of 2012? And countries like the UK very much were pushing for a risk-based approach to data protection as part of the reform. And yes, risk is referenced repeatedly, peppered throughout, particularly the recitals, but even in some of the written text. But I would argue this isn't the true risk-based approach that maybe I or others of my ilk hoped for, because when you actually analyse when risk is mentioned, it's almost invariably either to offer an interpretation of an already open textured aspect of European data protection, which frankly already was risk-based. I'll offer a few examples. Or it's integrated into entirely new duties on those who determine the purposes and means of processing, controllers or processors, people who are processing on their behalf. New duties, which yes, in some cases are risk-based, but many, many other new duties, again, some I'll mention, take no account or no explicit account of divergent risks in processing at all. So what I'm going to do is I'm going to look first at some aspects of the GDPR which offer continuity with the existing approach. And some, when the process was being drawn up, said much of the regulation was a carbon copy of the existing European data protection rules. And I have to say, I thought that it was largely a continuation in many ways with the existing approach. I think in reality we've seen more change than I or many others predicted, but we'll come to that later in the talk. But I'll start with some of the bits which are a continuity, then look at some of the bits which are a change, including in particular the ones which establish new duties which don't seem to take account of risk or context, and then come to a few conclusions. So some continuities first. Well, the basic structure of European data protection doesn't change that much. The purpose and material scope doesn't change that much, and I'll talk about that in a moment. But what happens when you're within the material scope remains broadly the same. By default, you must obey, as a controller, certain quite broad principles and the need for a legal basis. You must obey much more detailed substantive rules if you're processing any sensitive personal data. These are quite broadly defined: the revealing of racial and ethnic origin, religious or philosophical belief, trade union membership, criminal convictions, their health status, sex life, these sorts of things. You must always obey some more detailed rules around the transparency of your processing for the data subject and around ensuring them a measure of control over data. And then you must also ensure that your processing is disciplined through some rules focused on anchoring these things in a system of discipline and come under various supervisory structures. So all of that you could map back onto the existing directive. And you also could map onto the existing directive the fact that, yes, there are some exemptions and derogations, which again I'm going to briefly note, but I realise this talk already is going to cover too much material. So why does the scope remain pretty much the same? Well, we're still talking about a dual objective, and in some ways two objectives in tension with one another, of protective human rights and the free movement, the more economic in many ways, but also other rights like freedom of expression, the free movement of information, particularly within the European, well, essentially within the European Union itself. That's how it's specified. There's a greater emphasis on the protective human rights though in the past. It's now based on a protective human rights treaty basis, the protection of personal data, no longer on the free market or the internal market basis. The very first recital is about data protection as a fundamental right. And the protection in particular of privacy has been removed with simply the protection in particular now of the right to data protection itself. Whilst I can understand the logic of that, I do worry that that makes the goals of data protection ever more opaque. Because at least when we were saying that, well, it was in particular about securing individual privacy, there's a long history of thinking and jurisprudence around what that might entail. In a way, it becomes rather circular if you say, well, why do we have all these rules in data protection? Because there's a fundamental right to data protection, and that's why we need the rules. It sort of goes round and round, and it becomes quite internal. The material scope remains extremely broad. Any processing, any operation, including even holding the data or deleting the data, on an identifiable or identified natural person is covered. It is clarified that deceased are not natural persons, evidently. But there's no suggestion in the text that innocuous personal data isn't covered, or that public domain data is not covered. And in fact, innocuous and public domain data, European regulators say, is covered, such as that the name of an elected public official would be personal data on this account. David Cameron is the UK Prime Minister. The breadth of personal data is actually slightly expanded, mainly on the identifiability side of the equation, by reference to saying that location data and any online identifier, maybe inside a cookie or such like a tracking on the internet, can be identifiable, or may well be identifiable. And that is obviously trying to say that in the age of big data, personal data will remain included within that, and that there will be a broad scope to protect people online, and I can see where they're coming from in that. But the breadth as regards not really trying to anchor it to the purposes of privacy or whatever else seem rather more problematic and remain totally untackled in the reform. The exemptions also remain very, very narrow, at least in the private sector. Notably, the reference still to only excluding, even as regards natural persons processing, purely personal or household activity, which we know in Linguist anyway, in 2003 by the Court of Justice, was interpreted as excluding any publication to an indeterminate number, even by a natural person in the context of their recreational activities on the internet. And we know from the Rhinez case much more recently, even captured various forms of household CCTV recording. I'm not going to talk anything on the directive on police and justice. I'll leave that to Nora. You can talk to her after this talk. But there's obviously change there, which is broadening, but not within the context of the regulation itself. So yes, some change. We're already beginning to see that the change is on the side of breadth and on the side of protective human rights, and I think that's going to be a leitmotif in a way of the more substantial changes, but an awful lot of continuity. and an awful lot of continuity on the basic principles of data protection. So, and again, without sort of going through the entirety of the current structure of data protection, we're talking here about fairness, the need for a legal basis to process, purpose quality, purpose limitation, information quality, like accuracy, and information limitation. And the changes here really are again broadening and tightening. So it used to be that those principles were at least labelled up as about data quality, which tended to suggest that they weren't aimed at covering the whole field of data protection in a kind of principled way, but were narrowly focused on particular aspects of it. That's now gone. They are just sort of the data protection principles. And added to that, we have new principles. I think there's a principle essentially of accountability, but there's certainly a principle on integrity and confidentiality, which is essentially now data security, which was never on the list. There's an explicit reference to transparency, whereas it used to only be through a recital interpreted as part of fairness. And there's some attempt at what is seen as a tightening, such as replacing the word non-excessive collection or processing of data with the idea that it must be necessary to your purposes to collect any of the data which you are processing. And there's again, as a tiny little bit of an aside, given the fact the last data principle anyway said you shouldn't be holding any personal data for any time where it's not necessary, I doubt that in theoretical terms it makes much of a difference, but certainly it flags up more the need for a necessary connection. All the principles are actually given some short titles, which I think was a reform by Jan Albrecht, the rapporteur in the European Parliament. I suppose that was to try and make this all a bit more legible, but there are some strange aspects to that, which is that one of the aspects and the principles is that the data must be adequate. There must be enough of the data for your purposes. So if you're a credit rating agency, you better be collecting a coherent and complete set to offer a fair service. And yet, the principle, which is partly about adequacy, has been labelled data minimisation, which seems a bit strange given the fact that part of the principle is potentially about ensuring you're collecting enough data, not a minimisation of the data. So another aspect is that you must have a specified legal basis to process, and there's 6 of them in European data protection, and there'll be 6 of them in the future. So there's, again, a lot of continuity, but all the changes that we do see are, again, focused on making things more onerous, making things tighter. So the broadest and probably the most controversial legal basis is simply that the controller's legitimate interests outweigh the legitimate interests of the data subject in exercising full control over their data relating to them. That ground remains, but it's now not going to be available to public authorities in the performance of their tasks, which will mean that there'll have to be some specific vires set down in law for those activities, which could potentially get rather bureaucratic, frankly. Those legal obligations, in turn, are now explicitly going to require a proportionality analysis. Now, that was implied in the European case law anyway, in things like the Rundfunk decision way back in 2003, but it's now in the text. Perhaps the biggest change, though, is around consent, which is the first possible basis for processing personal data, and it links to notions of informational self-determination, which are not actually, I think, required by European data protection law at the pan-European level, but have been a huge motivator for it. What consent means in European data protection has been made much more defined, and the definitions are all, again, towards making it more difficult to make out. So it's made clear that consent is rescindable. It isn't the sort of one-off consent like you might have in contract law. It can be rescinded at any time, which is quite a big change, at least from UK approaches, which often took it as non-rescindable. It must also be demonstrable in the sense the controller must be able to show that that consent is there throughout the period of processing, of even holding the data in any way. And if it is written down, which I think because it has to be demonstrated, it's likely that controllers very often will want to have it written down, then it must be that aspect of seeking consent, which must be freely given, specific and informed, must be distinguished and clear from any other material, such as a contract. So again, kind of making it much more up front and centre, plus being rescindable, is going to make it more of a challenge for controllers to rely on it. The sensitive data rules are again a similar picture of continuity largely, but the change being towards making things tighter. So some of the definitions have been broadened, but only slightly broadened. So sex life becomes sex life and sexual orientation. I would have thought that sex life probably already encompassed sexual orientation, but it's there now explicitly. And we have got an addition of genetic data, biometric data, but only if it's used in order to uniquely identify a person, sort of biometric purposes. And that's quite interesting because sensitive data has always, up until now, been purpose blind. It's simply that you are doing something with data which reveals or relates to or concerns certain aspects of the human person. It's nothing about why you're doing it, in theory. Now we have the addition of a new ground which does talk about the purposes. Now, the default with sensitive data, at least in the private sector, is that the processing is completely banned, at least absent this consent, which we now know must be rescindable even, and must be very clearly specified and freely given, or where that data is manifestly being made public by the data subject themselves. And those barriers remain pretty much the same, apart from this change of the meaning of consent. There's a little bit of wiggle room around the edges, a steer towards derogations for research and statistics and archiving, but it's still only a steer. It was going to be an obligation for there to be a virus there, but it got watered down. And states are allowed to have further limitations as regards genetic data, biometric data, or health data. So they could go for something approaching an even more total ban with that kind of ultra-sensitive data. It's quite interesting that this is obviously a compromise, because genetic data and biometric data is protected at the pan-European level if it's used for a particular purpose, but at a national level it could be protected irrespective of purpose, which again kind of exposes the tensions, or some of the tensions. So gosh, that is all largely continuity, but I feel I'm already kind of talking through quite a lot of change. But there are other aspects. The next two aspects of the data protection regulation are very significantly about change, and that's the whole transparency and control rules and all the different things to ensure that protection really is ensured through the disciplining of processing operations. So transparency then has, two or three aspects. It has the sort of privacy notice aspect, the aspect that if you're collecting data, then you may well have a positive obligation to go out there and tell individuals about it. And that aspect is the one where we see the most shift, the greatest shift to a prescriptive an even greater, more prescriptive approach. The other aspect is retrospective or retroactive, if you like, that the individual can contact you after the event and ask the data, the subject access right. We see less change there, but change in the same direction as the proactive privacy notice change. And then that's linked to control rights, to ensuring that individuals have a measure of self-determination, if you like. That would be how some people in Germany might put it. Over data, even if consent isn't necessary. And there are some significant changes. And I suppose all of these changes link to an emphasis which many in the European Parliament and even in the European Commission put on in the reform process of putting individuals in control of their data. Now, this idea of quasi-ownership has never been accepted in European data protection, again, whatever its relationship in specific national jurisdictions. But we do now see some language in the regulation which point more in that direction. In some points of the regulation, it is actually spoken about his or her data, this sense of quasi-ownership, which again, the directive resolutely did not have that language in it. So let's look a little bit at these proactive obligations to go out and provide information to individuals, these privacy notice type things. So the current rules make a fundamental distinction between where you're getting the data from. Are you getting the data directly from a data subject, talking to them, interviewing them, getting them to fill out a form? Or are you getting the data, the information in some other way? From a third party, or frankly, even from the public domain? That distinction remains, so we need to look at the two things in turn. Now, the old rules on so when you're directly collecting data from a data subject, the old rules were that you always had to tell the data subject who you were, sort of give a capacity for them essentially to contact you, and why you were doing what you were doing. But anything further depended on context. And this is why I say already built in a risk-based approach. Because anything further was only necessary if it was needed to guarantee fair processing, not otherwise. But we see a bit of a dramatic, potentially very dramatic shift in the new privacy notice arrangements. Because in Article 13, no fewer than 11 bits of different data are specified as to be provided. And they range from, yes, the purposes and identification, also if you have a data protection officer, who they are, but also quite technical things like the legal basis which you're relying upon, which I've just outlined. What legitimate interests you're pursuing if you're relying on that very open provision, who the recipients or the categories of recipient are, but then a whole even more detailed and granular range of provisions from whether you're going to transfer the personal data overseas in any way, and what safeguards you put in place, and where to get a copy of those safeguards. The storage period, all the different control rights individuals have, the fact you can withdraw consent if you're relying on consent, the fact you can complain to a regulator, the presence or absence of automated personal decisions. Now, you'll notice that this slide has some things in a nice circle, and then some things in a hexagon. So only the first four are in a nice circle, and then we get to the hexagons. And that matters, because the ones in the hexagon are based on the sub-paragraph of that article, which states that they need to be provided because they're necessary to ensure, or I'm paraphrasing, to ensure fair and transparent processing. Now that was going to read that you need to provide the information that is necessary to ensure fair and transparent processing, which was anchored in the old contextual risk-based analysis, which is it may or may not be necessary for fair and transparent processing. You need to look at the context of really how risky is it to the individual for them to be proactively told all these details. And the Information Commissioner, even in the UK, is beginning to interpret the reworded nature of this clause as meaning, no, it all has to be provided. In any context, you're having an interaction with an individual, which, given how often we have interactions, and I don't know how broadly you're meant to interpret these provisions, but clearly we are collecting data from each other all the time in myriad sorts of ways, is so unwieldy and disproportionate potentially, that I think this is an aspect where we need to look at the wording. And can we interpret in a more contextual way? Can we say that the bits in the hexagon actually, because it refers to necessary, fair, transparent, we look to see whether it is necessary. And only when it is necessary do we need to do this. Similar issues occur when you're even greater issues occur in a way when you're collecting the data and the individual isn't even there. And maybe you're collecting it on a Google search even from the public domain or even from a newspaper. In theory, quite similar duties apply, and that would be the case under the current directive. But again, what we have now is a much, much greater list. This time, 13 categories of data are mentioned. And again, the Information Commissioner is interpreting already these things as things which always have to be thought about in privacy notices. And what's new, which isn't already in the hexagons and the circles I talked about before, well, obviously if you're not collecting it from the individual, maybe the individual wants to know what the data categories are, what actually you have collected, not just that you collected some data. So that's there as a circle. Strangely, the exports, the transfers overseas is now in a circle, not in a hexagon, which is sort of strange because things seem to just sort of flow in and out in a quite an unstructured way in many ways in these clauses. But there it is, it's in this context in a circle, not a hexagon. But in the hexagon are things like what source, where do you actually get this data? And to sort of demonstrate the breadth of these provisions, you're meant to detail whether that source is in the public domain or not, which I think shows that data protection is really intended to stretch fully into the public domain. But again, we get this cut-off, this time at category 7, which is that some things need to be provided with a link to necessity of fair and transparent processing, and some are obviously categorical. And again, we need to look at whether we can contextualize that interpretation. Now, obviously, I hope it's obvious, there needs to be some limits, at least where data is being collected on things like a Google search, from needing to go out and relocate individuals. You know, you're collecting information on someone who might come around and repair the plumbing in your business office. Presumably, you don't need to go and send all or even some of these details to the plumbers you're not intending to employ in order to detail that, because they probably wouldn't be all that interested. So what are the limitations? Well, under the old law, they were based on a disproportionate effort criteria, and anything which was further specified in national law as required, therefore, to safeguard individuals in the absence of notification. And quite frankly, it was a bit of a mess in terms of what countries said needed to be done. In the UK, we have this vague requirement to specify the reasons why you've determined it to be disproportionate. I'm not sure at what level of abstraction you're allowed to do that, but that's what it says. It's not exactly been flagged up very much that is a requirement, and I wonder to what extent it's very much complied with. Under the new pan-European harmonised provisions, there are no exemptions really if it's direct collection. The only exemption, but it's not really an exemption, is if the individual already has the information. But that's not very likely, at least with that very long list, that they're going to have all of the information. If it's indirect, yes, you can rely on disproportionate effort, but only if you're taking measures to protect the individual, okay, that's based on the current law. But only also if you're making the information publicly available. Now again, this seems very unfortunate language because, let's go back to this slide which shows you all 13 categories of data, which even in an indirect situation of data collection, you may be having to provide. If you say, okay, no, that's disproportionate. It's disproportionate to tell absolutely every individual on an individualized basis what categories of data I've collected, where I might be sending the perhaps anyway public domain data onward to or outside the European Union, what exact source I've got the data from and how long I'm going to hold it for. But if you then say, well, you can only not do that if you're making that information publicly available, at what level of granularity are you meant to go down to? Any organisation, or frankly even any individual, is going to be processing hundreds, potentially, of different bits of data for different storage purposes, different categories, different recipients, maybe different data transfers every single day. And what are they meant to do? Can they have a very broad privacy policy, which in very, very broad terms says, well, we may be collecting these types of data, we can't really tell you how that relates to specific purposes, but we can also tell you a bit about our purposes? Or is this really an instruction to go down massively go right under the bonnet, if you like, into each processing operation, which would be very disproportionate? And the language really doesn't tell us, which is very unfortunate. And I'll come along also to the potential sanctions which attach to breaches of these requirements, which I think will make it even more unfortunate. Okay, so I'm conscious of time, so I want to sort of press on. We've heard a lot in terms of I won't talk about retrospective transparency, subject access, because that remains very similar. But I will talk a little bit about control rights. And obviously the control right we heard most about in the process was this right to be forgotten. But in many ways that's not a particularly significant change, because there already was a right to erase data when it was when it was being illegally processed. And at least it's originally encapsulated. That was really what we were talking about when we talked about the right to be forgotten. The right to have that data erased if it really wasn't fitting with the European data protection rights which you have. There's some more significant changes in terms of control rights. The first one is that the right to be forgotten applies if the data has been or have been unlawfully processed now, which is a very strange use of language, because I can understand the notion that if the data is being unlawfully processed, then it needs to be rectified, and if it can't be rectified in any other way than by erasing the data, it better be erased. But the language has been changed to, you have a right to erase the data if the data have been unlawfully processed, which, again, whether this is deliberate, unfortunately opens up the prospect of a data subject who is particularly, unhappy, trawling through, looking for past misdemeanors, past failures around things like privacy notices, and lots of other provisions, and then saying, well, it doesn't matter, it can't be solved because the data have been unlawfully processed in the past, therefore I demand the data to be deleted. So that seems to be a potentially worrying shift. But it's an empowering shift for the data subject. And the other empowering shift is around this right to object. Anyone can object to any data processing relating to them. Now that's already in the current law. But what's new is that once someone objects, a controller can only continue to process the data where this applies if they can demonstrate compelling legitimate grounds for holding the data. So it seems to sort of turn that legitimate interests on its head. So rather than the presumption being if you have legitimate interests you can process data, once someone objects, it shifts round. And again, focused on this idea of giving individuals more control over their data, or that's the language, over their data. Okay, so a lot more prescription around transparency and to a lesser extent around control. But I think that the sort of prescription that we see in some of the discipline provisions moves even beyond that. So there are three, and I'm going to try and cover this quite quickly, there are three key duties to discipline controllers and processors. There's some sort of general duties around security and integrity. There's some more specific duties which came out of this, you have to notify or register processing with the regulator. And we'll see what happened to that. And then there's the very confusing provisions around trans-border data flows, transferring personal information overseas. Security and integrity, again, always used to be largely risk-based. It used to be based, and still is to a significant extent, on appropriate technical and organisational measures to ensure the security of data. And security defined broadly, not just to mean the loss of data, but any unlawful processing. Sort of to take technical and organisational measures as a controller to stop unlawful or unauthorised processing, including its loss. That's still there, but we have some new open texture duties to demonstrate compliance, to ensure data protection by design and default. Okay, we might not be too troubled with that because again it's sort of open textured and risk-based. But we have the addition of new prescriptive duties as well. Some around data breach documentation, which appear to be non-risk-based, although the obligations to notify individuals of data breaches and the regulator of data breaches is risk-based. But I'll bracket that, I think, for interest of time. But the relationship between those who are determining the purposes of processing and those who are merely processing on behalf of controllers is made an awful lot more complex and an awful lot more difficult to comply with through non-risk-based provisions, which I think I will spend just a little bit of time to go over very quickly. So, the old rule on what do you do if you have someone or an entity who's only processing on instruction from you was already non-risk-based, but it was relatively simple. It was that you need to have a contract or some other written act which says you must only operate on instruction from me, and you must also sort of have some due diligence to see if you've located someone who is capable of taking security measures that you need to be obeyed. And so it's prescriptive, non-risk-based, but relatively simple. What happens is that the new provisions in Article 28.3 now says that this legal act, this written act, needs to be very, very detailed, definitely. It's not enough just to say, process on instruction from me and I'll give you the instructions, and therefore if you act outside that, you are acting illegally. The written act now evidently needs to detail the subject matter which you're giving over, the duration of the processing, the nature and the purposes of the processing, the type of data, the categories of data subject, the controller obligations and rights, the documented instructions including as regards the transfer of information overseas, no unauthorised processor, no onward processing operation, which is very common actually in terms of an onward change for the purposes of efficiency, and requirements to delete or return the data after it's been processed. Again, you could say that was implicit, but evidently it needs to be explicit. and various explicit requirements to assist with impact assessments, assist with auditing. You know, it's for any form of processing, evidently, which involves the use of someone operating or an entity operating under instruction. Again, desperately non-risk based, and with no real understanding of what is a processor. You know, I think we tend to think of a processor as somebody who gets hold of data and has it there before them and then does something with the data, but they really should only be doing very specified things with the data, such as a call centre, which is doing call centering for lots of different organisations with data from those organisations, but has to actively manage that. But if you look at the definition of processor, it seems to be a heck of a lot more broad. That anybody doing anything with data, even holding the data potentially, could be seen on some criteria as a processor, and that would tend to mean that any cloud service was a processor, even Gmail or Hotmail or Google Drive. And if you go down that line, which the Queen Mary University of London team, which have been looking into cloud computing and data protection for a number of years, do, Quan Hong from that centre has described the whole provisions as cloud impractical. And in fact, her blog on this is entitled Killing Cloud Quickly, suggesting that actually if this was applied, it simply could not be squared with the nature of the cloud. And how on earth could you specify this level of detail for every single situation where an entity might not even know they're processing personal data, but in fact they are, because it is actually being stored on their servers, if you like. So, if we look at discipline provisions, actually the Commission went on and on throughout the process that this was an area where there was going to be less prescription. Because yes, we used to have this, and we still do, I suppose, because the current regime is still in force, have this rather strange duty to register all processing, or by default all processing, with the regulator, with the data protection authorities. And they made a huge deal of the fact that this duty was going. And wasn't that going to be marvellous, and it was going to save billions of euro, evidently. What we got instead, though, in the final text, was a duty for controllers to register their own processing and keep a record of that processing, including the purposes, the subject categories, the data categories, the transfers overseas, the time limits where possible, the security measures, essentially largely the same criteria as they used to send to the regulator, now will be needed to be kept by them, and it needs to be made available to the Data Protection Authority on request. So I don't really see that's made a great deal of difference. In fact, the only real difference is that now the controller has to make sure that they store the data. They can't just send it off and say, you take care of it and you deal with it. It now has to be stored by them. How that is a great saving, I don't know. And even more than that, under the old law, member states could determine processing which was unlikely to present a risk to data subjects. Again, this was a risk-based approach, but under the old rules, not the new rules. And they could exempt from registration. And they could also exempt from registration if they said that there was a statutory data protection officer in place. So that was actually used a lot in Germany. Under the new rules, that won't be possible. And the only exemptions, at least in the text, will be at the pan-European level. And they'll only be available to organisations with less than 250 employees. Okay, you might think, well, that's a heck of a lot of organisations. So wonderful. But only then if the processing is unlikely to be a risk to the rights and freedoms of data subjects. So, okay, a bit like the old member state law, but now only restricted to relatively or medium and small enterprises. But in addition, only if the processing is not occasional. Well, I thought any organisation is going to be doing some processing which is more than occasional. So that already means that almost nobody seems to be actually fully exempt from these duties. And only when the processing doesn't include sensitive data. Well, I would have thought every organisation is going to process sensitive data at some point, even if it's only someone emailing in to say that they're off sick, they've got a doctor's note for X. At some point in time, even an organisation which maybe only has 2 people working for it is likely to process some sensitive data, and that's just picking out one category, health data, that they might process. So I can't see that any organisation is going to be fully exempt from this duty. So again, I question how the Commission can put all this focus on the abolition of registration as this great achievement for the loss of red tape, because the red tape is still all there. And to the extent it's not, by the way, the UK Data Protection Authority wants to maintain registration at a national level by saying that because they rely on all the money coming in from registration fees, they're still going to press the government for controllers to have to register and pay money to them, but they can keep the information, but they still need to pay the money. Now, I hope that won't happen, but that is still what they say they're going to push for at a national level. The other aspect is the prior checking aspect. So member states under the current law are meant to detail very limited forms of processing which present such specific risks to data subjects, they need to be checked by the regulator. The UK has decided never to specify any data processing situations where this is made out. Some member states have detailed them. Now we're going to have a harmonised approach. And this starts with organisers or controllers themselves looking to see if they have any likely high-risk activity which they're carrying out. And if they do, they must undertake an impact assessment, check that they are complying with the law on a ex ante rather than ex post basis in a kind of documented and detailed fashion. Now, and one thing which will always definitely be that is the large scale, whatever that means, processing of any form of sensitive data, like health data. A prior consultation before processing is carried out, it then says, must be ensured when a high risk is deemed to be present in the absence of measures taken by the controller to mitigate that risk. Now, that potentially seems incredibly broad again. And I actually don't understand this wording. I mean, if you're processing a large amount of health data, it seems that you will have to, that will present a very high, if it's confidential health data, that is a high risk to data subjects. And so you'll have to take some steps to mitigate that risk, if it's only encryption or some kind of security measure. But surely it's not the intention of the law for then a consultation to have to take place in each and every case with the regulator in order to tell them that you're using encryption and various forms of sort of standard security provisions. But the literal plain meaning of the text might point in that direction. And again, the poor drafting of the regulation is shown by the fact that Recycle says something entirely different to this, which is actually breathtaking to me. The Recycle says you have to consult with the Data Protection Authority when, after having taken measures to mitigate any risk, a high risk remains present. Whereas the actual text says it's when the high risk was present before you took the measures, which is totally different, which is again rather problematic. I'm not going to talk about transborder data flows because time is pressing, but we see similar patterns there, at least from a UK perspective, in the sense that any transfer overseas of personal information, potentially, which we know is extremely broadly defined, is in principle banned, subject to safeguards being put in place, or derogations, safeguards to ensure that the same regime applies, or very specific, or a similar scheme applies, or they're very specific derogations. Now in the UK, the current law says that this only kicks in unless you fail to establish adequacy assessed in the circumstances of the specific type of data. Which, again, with a bit of wiggle room around what the law really means, has allowed the UK to have a self-assessment approach, where controllers actually look very much at, well, how significant is this data transfer? How long will it be in the country? How privacy invading actually is this data, if anything actually happened to it? That kind of provision, adequacy in all the circumstances, is removed in the new text. And so we've got a much more legalised sluice-gate model, which apparently will lock down VIRES for data transfer overseas in a much more potentially rigorous way. So again, similar concerns. And those similar concerns are compounded by this slide, I think, which is now moving to the actual enforcement. Because yes, we see enforcement has always depended partly on private enforcement through courts and private citizens, but that has never developed very much. But also through regulators, through these data protection authorities operating in all member states. And they're now going to be very, very significantly empowered. Because where it was a bit of a panoply of different provisions, including some data protection authorities which had no real coercive powers whatsoever, although perhaps they should have done, given the need, what was specified in the directive, they didn't at national level. They're now across the board going to have the potential to fine even individuals, but certainly organisations, up to €20 million or €10 million for some provisions, for violations of all of these rules I've been talking about. And in the case of large corporations, it's going to be even more, because it's going to be between 2 and 4% of their annual global turnover, which runs into the hundreds of millions for entities like Google, as I understand it, and Facebook, and would effectively wipe out their profits for a year, if I would have thought, if the full force of the law came down upon them. And you can see that most of this slide, which details most of the provisions I've been talking about, are all in red, which means that most of these provisions could attract the full penalty, 20 million or 4%. And even all of these discipline rules, which are really complicated, attract up to 10 million euros or 2%. And to make it even more extreme, it does say that in each individual case, the regulator is meant to administer a dissuasive and effective fine, as well as one that is proportionate. But I think that presumably they take, by and large, the provisions already to be proportionate. But if you have all of these provisions, we've gone through the transparency rules, and we've gone through the data processor, data controller, legal arrangements and written contracts, how on earth is this ever going to be applied? I mean, the data protection authorities did a survey of apps on the internet and found that potentially up to around 85% were failing to provide even the current transparency notices which are required under the current law. 85%. And yet these provisions seem to say that you need to fine up to a level which is genuinely dissuasive and effective. Well, I doubt that's what's going to actually happen. In fact, I can bet my bottom dollar that is not what's going to happen. But it shows you that the law is saying one thing, and what digital reality is saying is such another thing. And then we kind of leave data protection authorities in the middle, who are meant to try and make sense of something which in fact doesn't make a lot of sense. They're going to have to do that kind of not making a lot of sense, but trying to put sense into it more together now, because there's going to be a lead DPA where there are multinationals involved, which will take control of the conversations between them and the data controller, and then essentially any other DPA which has any kind of relationship to the processing takes part in joint operations, mutual assistance, consultation on these decisions which have to be made, particularly as regards fines, and ultimately all round the table they can issue opinions and eventually binding decisions if they wait long enough, could even by a majority vote, although it will before that be a 2/3 majority vote, which produce pan-European effects. So I mean, this deals in a way with the argument of many on the continent, if you like, who have seen large data entities like Facebook, in particular, Twitter, LinkedIn, establishing in Dublin, and there at least being an argument that they only need to talk to the Irish DPA or very often, although in fact there's case law saying that that's not the case. They need to talk to many other DPAs, but the reality has been they've largely talked to the Irish DPA, and this is the compromise, that yes, they'll talk to one DPA, but all the other DPAs are going to be involved, and eventually that one DPA, that lead DPA, can be forced to take action. It's going to be very messy, it's going to be very clunky, but it is a more harmonised approach. And again, you could say that's necessary in a very pan-European context, in fact a global context of data processing, but a pan-European context that we see now. I'm going to try and wrap up now because we're really running out of time. Yes, they are the derogations. They're the derogations for freedom of expression, which now will include academic expression alongside artistic, literary or journalistic, which I think is a great improvement, particularly for us sitting here in a university. And I'm actually saying something positive about or clearly positive about the European data protection reform. There's also a vague provision saying that member states should by law reconcile data protection with freedom of expression. But there's no specific extra virus for them to do that. So on a plain meaning of the text, they have to rely on general derogations. The general derogations being in Articles 9, 10 and 23, which cover some things but by no means all things. In fact, all of these discipline provisions, which are some of the most tricky and problematic provisions, are evidently non-derogable outside in the private sector, these journalistic, literary, artistic or academic purposes. Slightly problematic. And again, anyone thinking that the kind of Swedish data misuse model can be easily rolled out through the general derogations must look at quite the strict tests which need to be applied to any derogation. In particular, that the law needs to be quite tightly specified to the purpose of the processing, the categories of personal data involved, the safeguards, the scope of the restrictions, the specification of the particular controllers, the storage periods, the risks for data subjects, etc., etc. I think it's going to be a challenge for, I don't know if Sweden is intending to try and continue down using the national derogations to make broad inroads into the structure of European data protection. But again, this seems to lock down the derogations such that that's going to be more and more of a challenge. So some very quick conclusions then. I think when we started this process, I was somewhat depressed, but I was mainly depressed because I thought we have a broken model already. We have an overbroad model already. We have a model already which doesn't take context and risk enough into account, and we're going to see that continue. And I think what I didn't appreciate enough was that many, particularly in the European Parliament and to some extent in the Commission, were pushing for an even more broad and an even more prescriptive approach, and they might actually get quite a lot of that. I sort of thought, well, surely given the fact we've already understood that Europe is out on a limb in many ways in the industrialised world on this, surely that won't happen. But it has, to a large extent, I think. Now that has some positives to it. It does theoretically, comprehensively in the private sector safeguard individuals. It does raise awareness of something which I think is true, that we can't just let digital reality and large companies just say, well, this is now what's happening. There's no need for a democratic debate because this is the future. It does say democratic control protected rights are important even online, and we're going to do something about that. We're going to do something about that as a group of countries which is possibly powerful enough to do something about that. These are all great things. And I've gone through some of the provisions on harmonising across the EU. The fact that it goes even further into that, albeit in a rather clunky way, again, is probably an understandable structural shift. But let's look at the negative side of the chart. Are we any more clearer about why we need all of this breadth and why we need all of this prescription in each and every case? Are we any clearer about why we have data protection and therefore what the core of data protection really is? Are we any clearer about reconciling, not just in journalism, literature, art, or even academia, all of these rules and restrictions with the liberal freedoms that we have? Freedom of association, freedom of expression, freedom of movement, including the right to move regardless of frontiers, regardless of this trans-border restriction around Europe, for example. What are we going to do about the huge gap with practical realities, and what are we going to do about all of the somewhat implausible, in many cases, red tape stipulations, even when another fundamental right is not necessarily engaged all that much? So yes, change will be much more considerable than I understood it under the GDPR. And I really fear that those pathologies and those difficulties will reach new heights under this new instrument. So I'm going to largely stop there, but to be a bit more constructive, what can we do looking forward? Well, I think we need to map out a constructive agenda to mitigate and potentially even reverse this. And the only way to do that is twofold. One is to develop a contextual interpretation and implementation of the regulation so far as possible. I've talked a bit about that, particularly as regards privacy notices, that maybe we can cut it to the point where it says necessary for fair and transparent processing, and say we can take context into account at that point. And implementation, yes, using those national derogations as much as possible to reconcile with competing rights. Further ahead, and this I suppose is the project for a decade or maybe 2 decades in the future, I think we need to develop a robust contextual form of data protection, which is actually a full alternative to the European current data protection model. But that, I suppose, is an argument for another day. So thank you very much.